fascinating, and I also think very topical, the talk, and we will have a discussion later. So our next presentation is by Eliav Lieblich. Shall I do this and then I'll give it to you? Eliav, who is graduate of Columbia University and the Hebrew University. He teaches at the Interdisciplinary Center. And his field of expertise include public international law of the use of force, international humanitarian law, human rights law, and international organization. He was a fellow at different places, got different scholarships. I won't give you all of that. All of that. Did different consulting roles, and the subject of his talk is Cosmopolitanism at the Crossroads, Hersch, Lauterpacht, and the Israel Declaration of Independence. And the talk draws upon a paper he co-authored with Yoram Shachar.
Okay, thank you, Eyal. And first, thanks for inviting me. And of course, I have to give credit to my co-author, Yoram Shachar, whose diligent work has produced the factual basis. And he spent years in finding these documents, so it wouldn't have been possible without him. So, in the spring of 1948, Hersch Lauterpacht, who was perhaps the leading international lawyer of the time and a very well-established cosmopolitan, secretly proposed a draft for the Declaration of Independence of the Jewish state of Israel. A Zionist Jew from Galicia, he withdrew from public Zionism during his time in Britain when he became the Hewell Professor of International Law in Cambridge. His re-engagement with the Zionist project during the period leading up to Israel's independence ran parallel with the tragic events of the time that have had an immense effect over his life and thought. Now, interestingly, the draft, which I have to add immediately was rejected, received almost no attention in the immense body that deals with Lauterpacht, both in international scholarship and in Israeli discourse. So this article that I'm presenting analyzes this episode in Lauterpacht's life in light of the historical events, his personal circumstances, and of course his general jurisprudence. And I've handed the copies of the draft so you can try to get the gist of it while I'm talking, because I'm not going to be able to really analyze it here. So there are several things that the project aims to achieve, and it's mainly about tensions. Many of them were already mentioned in previous talks today. First, it demonstrates the tension between a cosmopolitan outlook, which is what Lauterpacht is generally credited for. He coined the term that the state is only an administrative convenience. Okay, so very cosmopolitan view, and the establishment of a new nation-state built upon particular collectivist perceptions, a Jewish state, and how Lauterpacht tried to resolve these tensions. And we claim that he tried to reconcile these tensions in several ways. One, struggling to place the Jewish state within a gapless international order. Okay, there is a legal order, and the Jewish state is part of it. Two, utilizing his universalist moralist approach of international law expressed in works like the Grotian tradition in international law to advance a moralistic justification for statehood. And three, and here we see the tension, employing his doctrine of state and government recognition developed in the 1940s in order to advance seemingly neutral justifications for independence based on effective control over territory, or in other words, power. However, we demonstrate that this reconciliation is not entirely convincing. It falls to the usual pitfall of utopian apologetic swing that Koskiniemi has identified so famously. And we further argue that this reconciliation perhaps emphasized incoherences in Lauterpacht's own general jurisprudence, and also contributed to the fact that the draft was rejected by the Jewish establishment. Second, this is the second thing that this work does, it exemplifies the international lawyer's personal dilemma, perhaps more so of Jewish ones, between the need to belong to what Oscar Schachter called the invisible college of international law on the one hand, and one's own collective on the other. Third, and I might have to change this because of the elections, don't quote me on that, it's going to go to YouTube, but the story reflects a salient dilemma of Jewish international lawyers and also Israelis. Many of us face Lauterpachtian choices daily, namely between some form of Kantian universalism on the one hand, which is part of our legal thought in Israel, and the reality of a Jewish state on the other. And this is exactly the dilemma of a Jewish and democratic state, to the extent this is a dilemma, considering also the political developments here. So the paper first tells the story of Lauterpacht's draft and its rejection, interestingly, both by the Jewish establishment in Palestine and by his own cosmopolitan sympathizers. Ironically, the Jewish apparatus in Palestine thought that the draft was too diasporic, while the latter, the Cosmopolitan College of Lauterpacht, perhaps saw it as some kind of a threat to his construction as this cosmopolitan hero. And also we revealed the tension, like I said, between his universal moralism on one hand and his power-centric perception of sovereignty on the other, as reflected on his work on recognition of states and governments. And then we show how these tensions are manifested in the draft itself. So the story, I'll put it short, to set the scene, we were talking about early 1948. The partition plan, November 27, 1947, is collapsing. And the Jewish establishment, on the one hand, doesn't want to act unilaterally. That would be an upfront to the United Nations. But it also fears the imminent withdrawal and cancellation of the plan, like the Americans suggested. And on the third wing of this dilemma, they don't like the border regime that the partition plan suggested, so they had some interest to subvert it. And on April 12, 1948, the Zionist Actions Committee decides to move forward with independence. At the time, Lauterpacht is in New York. He's doing some work with the International Law Commission, and he interacts socially with Abba Eban. Okay, he was back then in New York. We all know then later on he rose to fame in the Israeli diplomatic apparatus. This interaction probably led to a non-formal invitation to work on the draft, and we don't know if anybody else knew about Lauterpacht's involvement at the time. He would give a copy. Abba Eban gave a copy of the draft to Moshe Sharet, who would be the Foreign Minister of Israel later on. He would take the draft to Israel or Palestine back then in May 11th, 1948, only 3 days before the actual declaration. So the draft arrives with Sharet as a total surprise in May 12th, 2 days before the Declaration of Independence. It lands on the table of Felix Rosenbluth, later Pinchas Rosen, of the nascent Ministry of Justice, and at the meeting of the National Administration in Tel Aviv, which is the nascent government, at the same day regarding the establishment of the state. Rosenbluth dramatically takes out the draft, starts reading it, and then passes it to Sharet. Sharet starts reading it, and then Ben-Gurion interferes. After a few minutes, we see the protocol. It says Sharet starts reading, Ben-Gurion interferes, takes this, pass it to a committee. The usual way to bury things in Israel, maybe other places also. So this is the last record of the draft. We don't know what happens later on. We are left only with narrative. The actual Declaration of Independence was very different. Our suggestion is that Lauterpacht's compromises have something to do with the fact that it was rejected. So, as we suggest, the draft's disappearance can be explained by the simple fact that it wasn't appealing to anyone. Okay, that's a bit pedestrian conclusion, which is kind of tragic because I'm not sure that international lawyers could deliver something else. First, it was rejected by the Jewish Israeli establishment. As we argue, this was, among other reasons, because the draft was too legalistically apologetic in its struggle to place the Jewish state within an international order. It was perhaps too cosmopolitan, too diasporic. And Uri Adin, a senior figure in the nascent Justice Ministry, says so explicitly, and I quote, in his diary. The language of the documents prepared by Lauterpacht, and this would be, I think, probably entertaining for the Americans among us, is engulfed in the spirit of American jury. He was not American in any way, by the way, Lauterpacht. If written in the land of Israel, it would have never been phrased in this manner, half sentimental, half apologetic, self-justifying. Even though the substance is okay, whatever, we have a proposal of significant value because of the great expertise of its author, but it's very far from being satisfactory. On the other hand, the draft was downplayed first by Lauterpacht himself. He wanted it to be kept secret. And later on by those associated with him. And perhaps the reason is that they didn't want to taint his legacy as a cosmopolitan with his Zionism. And of course the representative is his son Elihu, who in his biography of his father downplays his Zionism in a way that I found a bit unconvincing. He describes Zionism as, in its earliest form, this romantic perception of Zionism, developed when it could not then be foreseen that the fulfillment of this idea would lead to the sad contentions, British understatement, that have marked the development of Israel and its relations with its neighbors. Now, this is, of course, not convincing, because by 1948, if something was clear, that it was that Israel would not be established too peacefully, to say the least. And Lauterpacht, of course, knew that. And then later on, he came to Jerusalem, and he didn't become a binationalist. He didn't turn into a binationalist by the time. So I think his son is trying to conceal something, with all due respect. So there's a dual rejection, and I think it has to do with the two opposing pillars of Lauterpacht's jurisprudence that also kind of make this draft unconvincing. Namely, it reflected a swing in his thoughts during the 1940s between a moralistic view of international law, on the one hand, and a power-centric perception of sovereignty, manifested chiefly in his work on recognition of states and governments. And these contradictions found themselves into the draft and might have very well contributed to its ultimate rejection. So his moralist view of international law is basically based on the following two pillars. One, a gapless system of international law in which state action can always be analyzed by general legal principles that can be derived from universal morality, natural law, reason, or analogies from domestic law. Every shortcoming in the legal system is institutional, not normative, and emanates from the problem of self-judgment. That's the big, bogeyman. That's the devil of the self-judgment. That's the problem. We can solve this problem only if we have institutions that would judge international disputes. The result is that there is nothing strictly political. There is only administrative discretion exercised by states when they administer international law. The second pillar of the moralist thought in Lauterpacht's work is progress, world federalism, and human rights. Adopting an optimistic, progressive view of history, Lauterpacht believed that the universal values that underpin the gapless international system will lead to world federation that will bring an end to abusive sovereignty and self-judgment, and will entrench the protection of fundamental rights, the ultimate end of sovereignty. And Lauterpacht was one of the first international lawyers that really took this seriously. And this was reflected in his 1940s work in human rights. Now, this perception was contradicted by his work on recognition from the same time, recognition of the states and governments. You would think that this moralistic view of international law would kind of trickle down or influence his work on recognition, but no. When he works on recognition, the absence of collective mechanisms led him to conclude, not as expected, that mechanisms should be established in order to further a fair and moral perception of recognition, but rather that effective control is and should be the chief determinant of sovereign power and recognition, not arguments from justice and morality. Neither the manner attaining control nor the violence through which it is maintained are relevant. And he's saying this exactly in the period, the same time when he's writing about human rights as the end of sovereignty, which is peculiar. So there are different ways to explain why his idealism disappears when he talks about recognition, and of course we can't really prove any of them. But it's striking that he emerges as really an Austinian positivist when he describes what spawns rights of sovereignty: habitual obedience, right? Not anything else. This is striking for a guy like Lauterpacht. And we argue that perhaps some explanation for this duality in his writing has to do with his personal circumstances. First of all, in 1940, virtually his whole family, including his parents, brother and sister, were murdered by the Nazis. It is reasonable that it reinvigorated his belief that a Jewish state is something that has to be achieved by any means necessary. In parallel, the famous White Paper of 1939, Britain expressly rescinded its support for independent Jewish state in Palestine. So it became clear that a Jewish state, on the one hand, we really need it because of the events of the Holocaust. On the other hand, the British that Lauterpacht really admired are not going to give it to us. So it might we might have to take it by force. And this might have turned Lauterpacht to be more sympathetic to unilateral claims for recognition that are based on control. It might be, to conclude this part, it might be said that his seemingly contradicting writings on human rights and recognitions in the 1940s represent a Jewish dilemma of post-World War II, whether to embrace cosmopolitanism as an antidote to rigid positivism and to the events that led to the tragic atrocities of World War II, or rather to adopt some form of collectivism as a response to past atrocities and an anticipation of future dangers. So this brings us to the draft. I'll be very... I have some time.
Yeah.
Okay. So I'll be very slow. So if we look at the draft, and if you have time to look at it, it can be helpful. It's comprised of two documents, an act and a declaration. The paper has some suggestions why Lauterpacht divided the draft, but the underlying theme of the draft is an enormous effort to reconcile between the author's own competing notions, between a gapless international legal system and the aversion from self-judgment on one hand, and what was an essentially unilateral act of independence on the other, and between justice and an additional tension between justice on the one hand and effectiveness as sources of sovereign rights. In this sense, the draft demonstrates a clear pendulum swing between utopia and apology, justice and effectiveness. And the first theme is the Jewish state and the gapless legal order. The draft struggles to place the Jewish state within this legal order. This is because it's obvious that in Lauterpacht's jurisprudential world, a unilateral declaration of independence is not ideal. So it only could be formulated or described as a reaction to the failure of the international community and as an essential act of carrying out the will of the international community. So, namely, he focuses on the failure of the partition plan. And it's only because of this failure that the Jewish people incurred a residual right and duty, and I'm quoting from the draft, to give effect to international decisions regarding Palestine. Okay, so the Zionists are agents of the international will. They're not acting unilaterally. That would be self-judgment, which is bad. So the unilateral declaration of independence is a part of collective will. We can see that in paragraph 1 of the declaration. It's the second act, the second document. Now, not only do the Jewish people administer the international will, and this is relates to what Professor Forbath mentioned about Indians, maybe, they also proactively defend it against those that aim to undermine it. And he says in paragraphs 2 and 6 of the declaration, I'm paraphrasing it, considerable armed forces are in open and savage rebellion. Savage rebellion. Who is savagely rebelling? That's the Palestinian Arabs and their... that was before the Arab states joined. So the Palestinian Arabs are in savage rebellion against the decision of the United Nations, okay, not against the Zionists. And the term rebellion, of course, presupposes the existence of some sort of public order. Again, the gapless system. They're not only opposing the Jewish national home, but they also deny the international order in itself. And he says, if the law-abiding will of the Jewish people would fail to act against the power of aggression and destruction, the purpose of the United Nations will be itself curtailed. We could think about Benjamin Netanyahu saying something like this today. I don't know. So this relates also to Professor Forbath's comment, I think, about how some of these internationalists or Jewish liberals saw the role of Jewish politics. Now, so there is no self-judgment, but of course, closer examination reveals the magnitude of self-judgment that Lauterpacht reserved to the Jewish people. And how is self-judgment affected here? Lauterpacht separated what he called the essential purpose of the partition plan, which is statehood, and the procedural aspects, meaning border delimitation, very marginal, constitutional protections, etc. Statehood rights, Jewish statehood rights, were by no way dependent upon the actual use of the various instrumentalities of peaceful change as envisioned in the resolution. But who decides what's essential and what's procedural? As lawyers, for the lawyers in this room, we know that this in itself is an act of judgment. And by reserving the decision to decide, to argue that this aspect of a partition plan is essential and this is procedural, this is an element of self-judgment. And it seems that Lauterpacht was aware of this problem, because he immediately, and this is the type of compromises and attempts of reconciliation that are found in this document, he attempts to offset the unilateralism of the draft by subordinating the Jewish state's constitutional order to international law and collective enforcement mechanisms such as the ICJ. Now, he tried to do this in the UK also. He tried to advocate for an act that would subject the British legal system to international law. It didn't work. He tried to do it here. And we can imagine Ben-Gurion's reaction to a suggestion like this. So,
5 minutes, okay?
Sure, I'll make it even less. And so the tragedy of the draft is that precisely because of its belabored effort to separate between procedural and substantive aspects of the partition plan, in its attempt to confer international legitimacy via the gapless order, upon an essentially unilateral move, it reads more like a lawyerly defense rather than a self-confident assertion of independence. And the ultimate Declaration of Independence of Israel refrained from this type of discourse. It was more about entitlement and rights and history. It didn't. It mentioned the General Assembly decision as, but very marginally. And now it's, of course, a valid question whether an international lawyer can ever do it otherwise. Okay, because Kaniemi convincingly argued that there's something inherent in the way we argue that always falls into these pitfalls. But it says something about the role of international lawyers in such situations. Now, the second theme of reconciliation is between justice and effectiveness in the justifications for sovereignty. And Lauterpacht sought to justify the Declaration of Independence and entitlement for state rights on both of these pillars. Again, a swing between utopia and apology. So the act seems to step back from recognition. Remember, in recognition he said, recognition is only a product of power. It cannot be based on substantive analysis. Here he says, justice requires, in order to ensure the Jewish people's survival. The act also reaffirms the existence of the law of nature by asserting the natural right of the Jewish people to national existence. However, justice and morality, and this is also relates to previous themes, did not result in an adoption of the human rights discourse in the draft. It is mentioned here and there, but it's more an issue of collective rights, of justice for the Jewish people. He does mention the brotherhood of Jews and Arabs, etc., but in terms of international or even constitutional human rights, these are not the ends of sovereignty of the Jewish state, according to the draft. Now, of course, because he's aware of the conflict between appeals to justice and the logic of effectiveness, he also justifies Jewish independence on counts of effective control. And he says, and this is pretty laconic in the way he treats, the way he treats effectiveness. He says, Jews now in fact exercise the power of government, and the Jewish state ought to be recognized as independent. And we see that he's the very marginal mentioning of effective control also says something about how unattractive effective control is as a justification when it really comes to justifying your own rights. But I'll set that aside. So these swings signified his struggle to maintain coherency, but I think it accounts much for the draft's diminished vigor as a powerful document. So, as I said, it's interesting to note that the actual Declaration of Independence is relatively free from this apologetic utopian swing. It barely refers to effectiveness. Its key sources of justifications are, again, justice and historic title. I'm not getting into it. It's just the fact. Now, we can only speculate whether this swing between utopia and apologetics, so familiar to all of us as international lawyers, has played a decisive role in the Jewish establishment's decision to reject the draft. And if this was the case, it's a sobering conclusion regarding the ability of international legal argument to play a part in such dramatic instances, historical crossroads. And of course, more than anything, and this relates to our conference, it exemplifies key dilemmas in Jewish international lawyering and relates to some of the themes we have already mentioned. Thanks. I've made it?
Yeah, perfect.